Good evening, everyone. Thanks so much for joining us for tonight's program. We will begin in just a couple of minutes. Hang tight and we'll be right back. Hello, everyone. Thanks so much for joining us tonight for Ask Me, our educational webinar series. My name's Audra Hines, Vice President of Care Services for the ALS Association Golden West Chapter. I want to start by thanking a couple of our generous sponsors, the Ron Malone Care Services Fund, as well as the Morris Family Caregiver Initiative, for their strong support of programs like this one tonight. We absolutely could not make these happen without you. We're pleased to be with you tonight to discuss a topic that's relevant to everyone living with ALS. The financial impact of this disease on an individual and a family can be devastating and life-changing. The latest estimate is that the costs related to the disease can be upward of $200,000 a year for medical treatment, home care, and necessary equipment for speech, mobility, and transportation. And many of these costs are not covered by insurance. As some of you know all too well, families are often left in turmoil as they're hit with astounding costs in managing the disease. The Golden West Chapter serves to assist with managing these types of issues, whether it's helping to navigate insurance benefits, loaning out or helping with the purchase of a necessary piece of medical equipment or speech device, or offering a brief respite break for a spouse or caregiver. The chapter has programs in place to assist with specific needs. Please contact your care manager for more details on how we can help. And in an effort to have your financial planning questions answered tonight, I'm so pleased to introduce Christopher Young with the Alvarez Law Firm. Christopher is certified as a specialist in estate planning, trust, and probate law by the State Bar of California. His practice is focused on elder law, estate planning, probate, and trust administration. He has unique expertise in elder law, including Medi-Cal and veterans pension planning, to address the high costs of long-term care, special needs trusts for those with a disabled family member, conservatorships, and other legal tools vital to ensuring that families are protected. Christopher, thanks so much for being here, and I will let you take it away.
Hello. Can you hear me, Audra?
We can hear you. Thanks for being here.
Absolutely. And thank you for having me. Thank you to Audra, Jennifer, and Jenica, and the entire chapter for first, and make sure this works for everybody. And that is to show the my screen. Is that coming up there?
Yep, you're all good.
Okay, very good. So as Audra said, this presentation focuses on planning and planning ahead, and specifically addressing one financial drain that affects people with a diagnosis and their families in ways that they may not see coming, and that is making sure that their estate planning documents are in order, because the financial costs of not doing that can have significant impact on the estates and on the families of those who are living with ALS, and cause some real heartache, which I've seen personally. I have in both a professional level and a family friend who have been affected by this disease, and it's very important to me to try to help spread the word about some of the ways that we can plan and avoid some of the unforeseen circumstances that and consequences of not planning. And I've spoken at the local level with some of the support groups in the area, and I'm very happy to have the opportunity to speak with you tonight as well. So this initial slide here has to do with just ALS and estate planning and ALS, but there wouldn't be a legal presentation without a disclaimer. All I'm saying here is that I'm a California attorney, and the advice here is related to California, and it is information only. There's no official legal advice because everybody's situation is different. I am also licensed in Oregon, and I'll get to that in a second, but I just wanted to put that out there so everybody knows that, and I understand we have some people from other states, and I just want to make sure, although there may be similarities, this is California-specific information that we'll be talking about tonight. I'm with the Alvarez Firm. We're a Southern California law firm, and we have offices in Camarillo, where I happen to be sitting right now, Calabasas, Westlake Village, and Seal Beach in Orange County. I focus on elder law, estate planning, special needs planning, probate and trust administration, and litigation to resolve disputes in families related to those things. And our firm also handles business and real estate transactions and litigation. Sometimes we get to the end of the presentation and people say, well, who was that again? So I mentioned a little bit about myself. I am certified as a specialist by the California Bar in this area. And I have since I was 4. I am from the Rose City, Portland, Oregon. And the reason I'm here is this lovely lady, my wife, Sarah, and our 5 kiddos. But Sarah's family is here in Southern California, so that's why we're here as well. So to get started tonight, and I want to make sure that we stay on time, but also that I get a heads up if we're running short on time, because I want to make sure we have enough time for questions and answers. But to get started, let's start with a little quiz. I'm going to ask some questions. My goal tonight is to focus on some major points that we can all agree are important for planning ahead. They don't require necessarily that you go to an attorney, and we'll talk about the pros and cons of doing it yourself versus going to an attorney. But I want to have some takeaway points, some things that you can, at the end of this, act on and perhaps, hopefully, make life easier, ease your minds when it comes to these very important issues, and focus on what's more important, which is your family and all of that, and kind of put this to the side. So if we can do that tonight, that would be my goal. So we're going to address some misconceptions along the way. So I want to start with a true or false quiz. The question is, your spouse may make financial decisions for you even without a power of attorney. And we can't do show of hands like I do in live sessions, but the answer to that is false. Okay. In California and some of the neighboring states, we have something called community property. So there is some type of property that can be managed by a spouse without a power of attorney. But in most cases, a spouse is going to be asked for a power of attorney. It's a document that gives the authority to one spouse to manage things on behalf of another spouse, an ill or incapacitated spouse, perhaps. And it's very important that that document be in place. So let's talk a little bit about what a power of attorney is and is not. And let's focus first on planning tip number 1, and we'll summarize these at the end. But planning tip number 1 is to sign a comprehensive, durable power of attorney. And when we talk about signing, there are ways to sign that don't necessarily need a full signature. California has options for notarizing based on making a mark or the attestation of witnesses. So that, just keep that in mind if signing is difficult. But to have a durable power of attorney is vital. And it's the most foundational document that I create as an estate planning attorney. So a financial power of attorney involves 2 main players, the principal and the agent. That's the person giving the power and the person who is receiving or acting on that power. There is, as I mentioned, a do-it-yourself form, so to speak. It's a statutory form that was established by the state legislature. It's freely available. You can find it online, and it's written out word for word in the California Probate Code. That's a pro. I mean, obviously, if it's free and freely available, then that's great. A drawback to it is that it's very general, and we'll look at one in a minute here, but it's very general. It doesn't get to all the specific items that one might want to have in a power of attorney. So there are advantages and disadvantages to powers of attorney in general, and to using that state statutory form, and we'll talk about that as we go along. Other terminology that's important to know when it comes to a power of attorney are whether it's durable or non-durable. Durable and non-durable. A durable power of attorney means it continues after we are incapacitated. So if it has that word durable in the power of attorney, it means that once you're incapacitated, it continues on and your agent can act on your authority. A non-durable power of attorney, or one that doesn't mention the word durable, the principal must have capacity. You're just acting with the principal's authority, and the principal has to have capacity to give that authority. So make sure if you have a power of attorney that it says durable. Also, two other words that we need to know are springing or effective immediately. Those are two other terms relating to power of attorney. A springing power of attorney is something must happen to activate it. Some incapacity or some event must happen in the future, and at that point, the power of attorney comes into effect. An immediately effective power of attorney is exactly what it sounds like. When you sign it, it comes into effect, and we don't need that triggering event to happen. Whether one is better than the other depends on the circumstances. But I have a simple rule of thumb that if you trust somebody to do the right thing when you can't keep an eye on them because you're incapacitated, then you ought to trust them to be able to do the right thing while you do have capacity. And frankly, you can see if they do that, and you can fire them by changing your power of attorney if they don't live up to your expectations. So my general advice, particularly if you have a diagnosis, is to make your power of attorney effective immediately and not wait for some triggering event down the road. It also makes things easier for your agent because they're not having to prove something to third parties that the power of attorney is in effect. It just says it's effective on signing. The power of attorney transfers authority based on if there is a triggering, if it is springing, based on some event. It can be the certification by one or more physicians. I would recommend, if you do have a springing power of attorney, that you use the word doctor and not physician. And the reason is not every doctor is a physician, but very qualified doctors, and I'll give you an example, neuropsychologists who can very well speak to whether you have capacity or not, are not physicians under California law. So I would use the more general term if you have a springing power of attorney and make it effective on a doctor's certification. You also don't have to use two doctors. That seems to be the gold standard, but it often requires too much of a family to go and get that second doctor's attestation. So I recommend, if you're going to have a springing power of attorney, make that trigger as simple as possible for the person that you've asked to help you. You can also have the determination be by an agent or by a family member or a friend for you. And there's no right answer. Just so you know, in case you're wondering, a statutory form power of attorney does is not springing. It's immediately effective. So you don't
Christopher, we're having a hard time hearing you. I think your internet connection might be glitchy. If you can hear me.
have to worry about any of this if you use that state. Now, a power of attorney lasts or until revocation. I am on I wonder why that is. Let me check here. I'm going to do one thing,
Okay,
and if it
sure.
disconnects me,
I'm not sure if you're still there. You're frozen. Thanks so much, everybody, for your patience. Just a little technical difficulty here. We're going to try to resolve this, hopefully back in just 1 minute. Thanks for your patience.
How is this?
Yep. So far, so good.
Right. I had a client tell me today that they don't call it the internet, they call it the every once in a while net.
It's okay. It's all the world we're living in now. No worries. Are you able to share your screen?
Yes. Let me
Okay.
do that again. And I apologize for the
No sweat.
break there. How's that?
That's great.
Okay. So nothing I said was important. Don't worry. Just kidding. So the power of attorney lasts as long as the principal is alive, or until they revoke it, if they have the capacity to do that. If it's not durable, then it lasts until someone is incapacitated, the principal is incapacitated, or you can put other criteria in the power of attorney to determine when it terminates. One thing I get a question about all the time is, if my agent loses capacity, does my agent's agent have any authority over me? And the answer is no. The agent of your agent is not your agent. So don't worry about that. You don't have to worry about who your agent may appoint to manage things for them. It has no impact on you. But that brings up a good point as to making sure you name backups, because life happens, as we all know. And if you don't have backups in place, you could end up being left without an agent. And then there's the next step is conservatorship, which we will touch on very briefly, which we want to avoid if at all possible. So a statutory form power of attorney, when it comes to my office, makes me think something like this. It's a penknife. It can open wrapping paper in a bank account, but it doesn't do everything I necessarily want it to do. An attorney drafted power of attorney, especially by an elder law attorney or somebody that's focused on disability issues, may look more like this, a multi-tool. And you may never need that wine opener or that toothpick, but you're happy you have it if you do. So these are why we think about these issues. There are many options that are available to put in your power of attorney that may not be in that state statutory form. This is the state statutory form. You can see it lists who you are, who you appoint, and it has powers listed under A through M, which you can initial next to. And if you are okay with your agent having all those powers, you can initial next to N, right there, where it says all the powers listed above. However, keep in mind that each one of these powers, while it seems like it's substantial, are limited, and they're limited in the probate code as to what those actually mean. All right. So for instance, if you were concerned about public benefits and being able to go on Medi-Cal, if that need ever arose, or if you were concerned about making sure that your spouse or loved ones would be able to make changes to your estate plan if you were unable to, or to give away property if need be, or if it's something you would want to do but you're unable to. Those are just some examples of things that you cannot do with the state statutory form that you would be able to do with an attorney drafted power of attorney. So quickly, let me just run down. Here are some examples of advantages. They are private, economical. It's one of the cheapest documents an attorney can draft for you. It can be put into effect quickly. It doesn't require a conservatorship. You can do things on a trial basis and change your agent if you'd like. And you don't have to change title of your documents or of your accounts. Disadvantages are a third party has to be willing to accept the power of attorney. And there's a lot of fraud out there. And so we want to make sure that that banks and other financial institutions will accept the power of attorney and not give trouble to your agent. May not be fully understood by the parties involved. The agent may not be able to give to themselves. That's a power that has to be explicit. They don't have to account unless a court tells them to. So there's no court supervision, which can be a downside if your agent needs to have someone looking over their shoulder. And this is interesting. A principal retains authority to act. So this could be something where, this is more in the case of dementia, where somebody that has a power of attorney may then do things themselves, what they still have the power to do, that are against their own self-interest. And that would be a time when a conservatorship might be a better option. The powers transferred can be, as we've touched on, banking, gifting, amending or modifying trusts. If you ever want to have that authority, it has to be in both the trust and the power of attorney. So I'm just going to move on to our next planning tip, and that is every adult should have an advanced healthcare directive. This is the other foundational estate planning document that every person should have. Many of you probably already have one. Usually people, when they face a medical crisis or a diagnosis, this becomes something on their mind. They go to the doctor, they get talked to about this, the hospital or the doctor says, you really should have this. So a lot of people who are on this webinar may very well have one, but if you don't, you really should. An advanced healthcare directive has, just like the power of attorney, two main players, the principal and the agent. It allows you to make your wishes known regarding medical care and healthcare decisions. It allows you to name your agent. By the way, in California, this used to be two separate documents. And in the ALS Golden West estate planning handout that they offer, it does mention two separate documents, a healthcare power of attorney and a living will. And those are two things that an advanced healthcare directive contains. They used to be called those living will and a power of attorney for healthcare. What happened is people would become confused between the other kind of will, the estate planning will, and also power of attorney for finances. So because of that, the legislature said, you know, we're just going to put those together and we're going to call it an advanced healthcare directive. So that's the new term for that in California, or relatively new term. So it allows you to name your agent and any backups, and remember, backups are important. It allows you to address religious practices and preferences you may have based on your faith. It allows you to address organ donation. So these are things in addition to end of life decisions that you can make known in an advanced directive. Who can act as your agent? Well, the good news is pretty much any adult can be your agent, with the exception of your supervising healthcare provider. So your doctor can't be your agent, or the operator or an employee of a care facility you might be in, unless, remember the law, there's always exceptions, unless that person is a relative, a spouse, or a coworker of yours already. So basically, with some narrow exceptions, any adult that you want can make decisions for you in an advanced healthcare directive. Now, the transfer of power can be a little different than the financial documents. It is usually determined that you don't have capacity to give informed medical consent by your treating physician, but you can make it dependent on some other trigger, and that's fine. And again, you can make it immediately effective if you choose. There's no writing necessary. So with a financial power, something would have to be in writing to say that you didn't have capacity and there was a trigger of your springing power of attorney. But with the healthcare directive, advanced healthcare directive, it can be an oral determination made during exigent circumstances by your treating physician. It lasts as long as you need until you pass away or you revoke, or if it is contingent on you not having medical ability to give informed medical consent until you regain that authority. So if you were going into surgery, then the power of attorney, the advanced directive would stop being in effect once you came out of your anesthesia. Interestingly, unlike the other types of powers of attorney, it does continue on in a limited way after you pass away. It can allow your agent to direct the disposition of remains, request death certificates, those types of things. So it's an unusual document in that way. Not all healthcare directives, advanced healthcare directives, are the same. Any advanced healthcare directive is better than not having one, but there are, again, there's state statutory forms, or there's forms that you get from the hospital association or from your specific medical group. And what I often see happen is when it comes to end of life decisions, there are two big paragraphs, and there's a line next to each one, and you're asked to initial next to them. And I will sum up those paragraphs as one saying spare no expense and the other saying pull the plug. And most of my clients, at least, are somewhere in between that. They don't necessarily fall on one extreme or the other. They may want a more nuanced approach to end of life decision making. And you can do that with an attorney drafted healthcare directive. So if you do have an attorney draft your healthcare directive, you are able, or you should be able to, you have that attorney put whatever direction you want regarding nutrition, hydration, pain remediation, comfort measures, and all of those types of things that you may have an opinion on regarding care that you receive at the end of your life. Some people ask about a POLST, and I would expect this question to come up tonight if we didn't talk about it here. A POLST is not a replacement for a good healthcare directive. A POLST, in case you're not familiar with it, is a physician's order for life-sustaining treatment. It is, in some ways, the new DNR. It's a hot pink form, usually on cardstock, that directs how, whether we should have resuscitation and other types of questions having to do with what happens if we lose consciousness or stop breathing, etc. But it doesn't address all of the things that might come up in end of life or just having to do with medical care if we're not able to make decisions on our own. So an advanced healthcare directive is a more all-encompassing document. And in fact, your agent under your advanced healthcare directive could sign a POLST in California on your behalf. So I'm not saying not to have a POLST, but I am saying don't rely on just having a POLST. A POLST is intended for people with a terminal illness to think about these things, and it can be a good thing to have, but you also want to have an advanced healthcare directive. What happens if we don't? Well, it tends to be the loudest family member in the waiting room who makes the decisions for us. And so this is kind of a not very funny way of illustrating that. But medical providers often are just turning to the person who's the squeakiest hinge. It is supposed to be our nearest adult relative who they will look to. But what if we don't have a spouse? What if we have several children? All of them have equal standing. You know, who do they listen to then? And so a directive is important because it really clarifies not only what your wishes are, but who you really want making decisions in those situations. And ultimately, if we can't agree and if the provider doesn't feel comfortable acting, then we have to look at conservatorship. And conservatorship in California is what happens when there's no power of attorney or no healthcare directive, or if they aren't enough to handle the situation. And I have slides on conservatorship, but I'm going to go very quickly and just say that there's three main kinds of conservatorship: probate conservatorship for people who are elderly, limited conservatorship for younger people who are developmentally disabled, and what's called LPS conservatorship for people who have grave mental disorders. And I'll leave it at that. And if anybody has specific questions during the Q&A about these things, I can talk about it then. So I'm going to skip these slides and we'll move on to our next topic. So you want to make sure you have the advanced healthcare directive and the power of attorney. Planning tip 3, having a will is better than no estate plan at all. All right. And the people who have found this out the hard way in history are, well, here's a few of them. We all know who this is, Dr. Martin Luther King Jr. And he did not have a will. And it turned out that his family fought for many years over two of his personal items that they prized very much. One was his Nobel Prize, and the other was his Bible. So again, having a will allows us to direct what's going to happen with our property, even things that may seem somewhat inconsequential or not be financial in nature, but are still important to those who survive us. Another rather famous example of somebody who didn't have a will is Prince. And last I heard, his estate was worth about 163 million and is still yet to be resolved. And a lot of people came out of the woodwork when they found out he passed away without an estate plan. Lawyers don't necessarily have wills either, and this is one of the more famous ones. Our 16th president died without a will. James Dean, this is kind of a sad situation. His mom passed away. He was raised by his aunt and uncle, but he had no estate plan, and so his father, who he was estranged from, received his estate when he passed away. So what happens if we don't have a will? We would go by what's called intestate succession, okay? That's the default plan that the state has for us. If you have a surviving spouse or issue, there's one plan, but if you don't, this is the slide that covers that. First of all, community property of your marriage would go to your surviving spouse. And if you have separate property, that's property that you received by gift or inheritance during your marriage, that would go either to your spouse entirely, or if you have children, it would go some to the spouse and some to the children. Here's how it works. All, if you have no children, half, if there's one child, half of your separate property to your spouse and half to your child. And if you have more than one child, then 1/3 goes to the spouse and 2/3 go to the 2 or more children to divide equally between them. Interestingly, there's one nuance I just want to point out here. If the deceased, let's see here, half of the separate property, if there's one child, goes to the spouse. But if the deceased spouse parents or their issue are living, so we're talking now about siblings of the deceased spouse, and there's no children, half would actually go to the siblings of the deceased spouse. So keep that in mind. Some people that may very well not be in your ideal estate plan, such as your siblings, may end up receiving property, separate property. And I've seen this happen in court, where very unexpectedly a sibling of a deceased woman came and claimed half the house that the husband thought he was going to get entirely. So again, these are reasons to have an estate plan, at least have a will. All right, and the issue, by the way, are our children, grandchildren, and so forth. So it's not just our children, but our issue that would take if we have children. If we don't have a spouse or children, then we look to parents, siblings, nieces, and nephews. We then, if there's none of them, we look to grandparents, aunts, uncles, and cousins. Issue of predeceased spouses, those are the stepkids. They get it if there's nobody else higher on the list. Then we look at next of kin. Then we look at our in-laws, the parents of predeceased spouse or their issue. And then finally, the state of California. That's the last resort, but only then do we have our property go to the state. So it's very, very unlikely, but it is possible at the bottom of that list for the state to take what's left of our estate if we don't have a will. So here's a true or false question. A properly drafted will avoids the need for probate. Some of you may be thinking that having a will avoids probate, but the fact is that that's not true. It's a very common misunderstanding, but having a will is really just a letter to a judge saying, "Dear judge, please do this with my property." And if you have a will, a judge is still going to have to carry out your wishes. All right. So probate is the court process to distribute your estate. In California, there's $166,250. That's the current number that you can pass without having to go through a formal probate. But if you have, that's the gross value, by the way. So if you own real estate in Southern California or in Hawaii, you're probably going to run up against that number because that's a gross number. They don't care how much your equity is. That's what's the value if you put that property on the market tomorrow. All right. And then remember, the existence of a will does not avoid probate. So if we just think of a will as a letter to a judge, then we understand that, why probate can't be avoided. And what's the downside of probate? I've practiced in 3 states, and California is where probate gets the bad name. It's costly, lengthy, and it is public. And I'll just give you a couple of examples of the size of an estate. A $400,000 estate. Remember, this is gross value, so very easy to hit that number in Southern California. That's $11,000 of attorney fees, $11,000 of executor fees. That's personal rep. That's what that word is. Your executor. So $22,000 if the executor takes a fee. If it's an $800,000 estate, we're looking at $19,000 in attorney fees. These are set by statute, and $19,000 in personal rep. There's $38,000. $1 million estate, $23,000 in attorney fees. And keep in mind, the court also gets other fees throughout the process. Every time you file a petition at the beginning and the end, it's $465. There's a court-appointed appraiser who has to appraise everything. They get a piece of the pie. So I would say truly in $1 million estate, you're probably going to spend, if everybody takes their fee, $50,000. So that's a reason to avoid probate, and why my next question is so relevant. And that is, true or false, trusts are often a good idea, even for those without substantial wealth. Well, if you think back to that last slide, you can understand why having a trust, why this would be a correct answer, and why having a trust just to simply avoid probate can make a whole lot of sense. So let's talk a little bit about trusts and what they can and can't do for us. And planning tip number 4 is to use a revocable living trust. That's the most common kind of trust we think about when somebody says they have a trust. It's a revocable living trust to maximize options and minimize costs. All right. So trusts provide many options. They help you manage your distribution of your assets during incapacity and at death. So a trust comes into existence when you make it. And if you can no longer manage your property, your trustee will change to the person that you've entrusted to manage things when you're not able. And that could very well be while you're still living. And then that person will make sure that your beneficiaries get your estate when you die. It helps you avoid probate costs and delay, maintains privacy and control. This is something that nobody has to know about. It doesn't go to court. And if you are subject to estate tax, which means that you have right now $11.5 million, then it allows for some estate tax planning. That's number 4 on the list because most people are not impacted by estate tax in the way they used to be just a few years ago. But it does allow for some basic estate tax planning through a trust as well. So a trust is a legal arrangement in which a trustee manages or holds legal title to property for a beneficiary. So there's a settlor, that's the person making the trust. If you are the person who makes the trust, you're the settlor, sometimes called the trustor or the grantor. Then there's a trustee, that's the manager. And the beneficiary, that's the person who gets the benefit of what's in the trust. And when you make a trust, you're usually all 3 of those. But over time, you may stop being the trustee, and at your death, you would stop being the beneficiary. Trusts allow the successor trustee, as I mentioned, to take over based on 2 different things: death, of course, but also incapacity. And similar to a power of attorney, you can put those triggers in for what incapacity constitutes, okay? And whether 1 doctor or 2 doctors or some other trigger constitutes the time for the successor trustee to step in, okay? You can also have different successor trustees for different situations. So you can say, at my death, I want this person to manage things, but while I'm alive, I want it to be this other person. And that's okay. You can do that. You may have reasons to. And then trustees may continue to act after the settlor's death, or, as I mentioned, a new trustee may take over at that time. When you have a trust, about the most important thing you can do is make sure you actually put your property into the trust. More often than you'd like to think, I end up with something that looks like this. This would be a trust that's unfunded. And if you can make the most beautiful suitcase in the world, but if you leave your shoes and clothes in the closet, it won't do you any good. There are some very famous cases, Michael Jackson being one of them, where a trust was created, but not all the property was placed in the trust. And so they had to go to court anyway. So make sure, because a trust can only control the assets that are in that trust, make sure that the trust is funded. All right. If assets are not transferred, they are not controlled by the trust. And you can look on most things like a house or a bank account at the title. How is title held? And if it says the trust name and you as trustee or whomever you've chosen, then it's in the trust. If you don't do that, you may still need to have a probate of that asset at death. All right. And if an asset is not in the trust for some reason, then the power of attorney would be used to manage that. And there are some assets we don't automatically put in a trust. Retirement accounts are a good example. Those are tax deferred accounts, and we would pay tax if we transfer the ownership to the trust on the entire account. So instead, we do other things with retirement accounts. But all after-tax assets really should be held in your trust if you have one. Generally, others don't have the ability to amend your trust, but there are good reasons, especially for people dealing with medical concerns, to allow a spouse to be able to make changes if need be. If a child, it turns out, ends up having a drug dependency, or if there's an accident or something like that, that we may want to change the manner in which we leave our estate to that child. Having someone authorized to make those changes can be a good thing. So it's very specific, very fact specific, but we always talk about that and the possibility of leaving your agent under your power of attorney with that authority. Here's another true or false question. Adding a child or grandchild as a joint tenant is an easy estate planning tool. Well, it may be easy, but it's not an estate planning tool that we should be considering. So I say that's false. And I see day after day examples of how this can go wrong. So this leads to planning tip number 5, our final planning tip for tonight, which is to be very careful with non-probate asset transfers. Transfers of property in some other way than by probate or through a trust. And the most common of those is joint tenancy. Now, there's 2 main kinds of joint tenancy. If you are married, then you probably have a joint account with a spouse or many, and that's fine. So married couple joint tenancy is common and accepted and understood, and that's fine. That's not a problem. But it's non-spouse joint tenancy that we're concerned about. So married couple joint tenancy is like community property. It's not quite the same, and I can get more into that in the questions and answers if people would like, but it's very similar, okay? The thing is, it delays probate, but it doesn't avoid it altogether, because at some point, the second person on the account will pass away, and there still has to be a plan for where that account is going to go. But at least at the first death, it just transfers to the joint owner, and that's fine. Non-spouse joint tenancy is perhaps putting a child or a grandchild or a sibling or somebody else on title with you. And what does that do? Oftentimes it results in loss of control of the asset, creditor risk. Now their creditors are your creditors. And if there's an accident or a lawsuit or a divorce, all of a sudden that asset is on the table. There's possible tax disadvantages to doing that, having to do with gifting and property tax issues and things like that. And if we're worried about it, there's also possible public benefit disqualification. So Medi-Cal, things like that. We have to be very careful about how we gift assets. And frankly, when you place a non-spouse on an account or on an asset, it's a gift. And you're making that gift now. So another way that you can leave assets without probate is by beneficiary designation. That's a very common way of doing it as well. We think of that with life insurance, retirement plans, which we touched on earlier. So I know someone asked a question of Audra about IRAs and how to handle those. Retirement plans, you place a beneficiary on the account, and that passes at death to that beneficiary. Annuities are another kind, and other contracts or accounts. Very common situation on bank accounts is to put what's called a pay on death, or with an investment account, something called a transfer on death or a TOD. There's even a kind of deed in California called a transfer on death deed, that you can leave property to a beneficiary at death. But be very careful with this. It's being tested, and the current law expires at the beginning of next year. And so, yes, it may fit a certain specific type of need, but we need to be very careful. And my biggest concern about it is it doesn't have contingency planning. What happens if that beneficiary dies before you? And then we're back to the same situation of going to probate, and perhaps going to probate with intestate succession and leaving our assets to somebody we don't intend. So it's not a substitute for a properly thought out estate plan, but just be aware that that's an option. So use with caution. That's my warning. Other types of transfers without probate, if you die and you have assets. Remember, I mentioned at the beginning of this talk, or close to the beginning, that if you can transfer $166,250 of property without a full probate. All right, so you have to wait 40 days. And if that property is not real estate, it can be passed by affidavit. So this is a fairly straightforward process that I can assist with, or another elder or estate attorney can assist with. to pass that without probate. If you have more than $55,425 of real property, which unless you have the tiniest slice of a pie in a vacant property and somewhere in this state, it's probably going to be more. But in some cases, you're under that number. You have to wait 6 months, and then you can do it by affidavit. And by the way, that 55,000 is part of the 166. So of the 166, only 55 can be real property. What happens if you have more? What if there's real property between 55,425 and that 166 number? Well, then you still have to go to court, but it's a lot easier than a full probate. So it's a one hearing, one petition, fairly simple process to get the court to transfer that property to you. And then finally, if you're married and your spouse dies and they leave property in their own name, you can use what's called a spousal property petition to get that property transferred over to you. And the court confirms that the property is yours or actually transfers it, depending on how the property is held. So I know we're coming toward the end of our time. I just want to summarize the points that we talked about, how a good estate plan can ease your mind. And like I said, you really don't want to think about these things any more than you absolutely have to. So think about them, get them done, and move on and focus on more important things. And these are the tips that I have for you tonight. First of all, sign a comprehensive, durable power of attorney. Do that right now if you don't have one. All right. Start with a statutory form if that's all you have, and then perhaps look into having an attorney help you with a more comprehensive one. Have an advanced healthcare directive. Having a will is better than having no estate plan at all, because then we don't have those default provisions that I went through rather quickly. Use a revocable living trust to maximize options and minimize your costs and avoid that cost of probate. And be very careful with non-probate asset transfers. All right. And with that, I would ask, how's your plan? Have you done all you can to avoid conservatorship by having those documents in place? Do you have a current estate plan, or are you on the state default plan, as many, many people are? Does your plan maximize the amount that will go to your beneficiaries by avoiding the cost of probate and other expenses? I have yet to have a client say, I wish I'd waited longer to do this. In fact, everyone says, boy, I should have done this a long time ago. And now, for people that are facing a diagnosis, that, in a way, it may be a little bit of a blessing to say, now we have a warning, now we have a heads up, this needs to be done now. So let's take care of it and move on to more important things. So with that, I ask for any questions that might have come in. Audra, if you have any that you want to send my way. And I do want to mention real quickly, I do a complimentary initial consult. So if there's a question you have but you don't want to ask tonight, or if I say, that's a little more detailed, so let's talk about that offline. What I mean is, let's set up a complimentary consult. We'll talk by phone or by Zoom or whatever you like. And answer that question in a quick consultation and not do it in the public setting. And I do want to thank you. I mentioned my wife's name is Sarah. And so an easy way to remember my phone number is 805-246-SARAH. So you'll never forget it now. But let's go back to those questions and any that Audra might have there for us.
I love it. Thank you so much, Christopher. This has been such great information. We do have a few questions that have come in. I'll start with the live questions, and then if we have some time, I'll go to a couple questions we received before the webinar started tonight. One question, is there any restriction against having an ex-spouse as your durable power of attorney?
So I'm going to ask a clarifying question, or I'm just going to answer it two different ways. If the ex-spouse, if you appointed that ex-spouse before they became your ex-spouse, then that could be an issue. Technically this falls under family law, and I don't want to say I've got the right answer, but without doing a quick amount of research, but I would say that I would be very careful about a power of attorney that was made prior to the divorce and then trusting that it's going to work. If you really want that person, and many times there's a divorce, but it's a friendly divorce, and you do want that person, at a minimum, you should reappoint them after the divorce. So there's no question about whether you intended them to be your agent. So I can't say off the top of my head that it would automatically work, and in fact, I think that if somebody challenged it, that person would probably not be allowed to do it. And so you really want to make sure you reappoint the person if you truly want them to be your agent. Does that help?
I think so, yeah. I'll see if she asks a part 2 to that. Can the power of attorney part of an advanced healthcare directive be effective immediately?
Right. So like I mentioned, that it was 2 documents at one time. It was the
Mhm.
living will, which was here's what's going to happen when I'm incapacitated or when I'm close to death. I don't want this. I do want that. That piece of it would only really come into play when you were close to death. So the only part that otherwise would come into play is the power of attorney portion of it. And so, yes, you can make an advance directive immediately effective and say, look, on signing, I'm just going to cede all of my medical decision-making authority to this person. I think a doctor might challenge that a little bit and say, well, you're obviously able to make decisions yourself. Why are you asking this other person to do that? But as a practical matter, yes, you can do that if you want to.
Okay, great. One more piece. If we have a trust and we want to change small details, can we do it ourselves with a public notary?
It's a great question. You know, if you want to get down to brass tacks, a trust, unless the trust requires it in the document, just under default trust law, you don't need a notary public. Just a signed document can be a trust. There are things such as oral trusts in California. So, but be very careful with that because things can go wrong. I'm just saying that, you know, the requirements are really in the document itself as far as what the amendment process would look like. And most trusts have a section that says this is how you amend, and most require there to be a notary public. The other thing is, if the trust holds real estate and you're ever going to be recording that trust as part of the management, you really want to make sure there's a notary, because recorders, county recorders, want to see a notary public. So can you do it yourself with a notary? Sure. And we can also cut our own hair, and we can also do a lot of things by ourselves. But I recommend that you at least have some, you know, if it's important enough to make the change, have a professional look at it and make sure it's being done right. Because the worst case scenario, and I see it happen from time to time, is that somebody did it on their own, left some ambiguity, and now we're spending a whole lot of money in court trying to figure out what you meant.
Okay, thank you. That's very helpful. Is there anything that can be done to prevent someone from contesting the trust?
There is nothing that can keep somebody who has about $500 and an axe to grind from filing a lawsuit. That's the unfortunate reality of living in the legal system that we have. It literally costs $465 to file that lawsuit. And if they're upset, they can do it. But you may be thinking about what's called a no contest clause. And in a trust, you can put a section that says, if any beneficiary that I've named here doesn't like what I did and they contest this, then they get nothing, or they get $1, or whatever the case may be. And you may have seen those, and your own trust may have one. Here's the problem with that. In California, a lot of the teeth in the no contest clauses have been removed, because if you can show that mom or dad or whoever it is may have not had capacity, or may have been under what's called undue influence by somebody else at the time the change was made, then the courts have said you can bring that contest anyway and you won't lose your inheritance. If it's, even if you're wrong, but you've made what's called a colorable claim, you've made a legitimate claim that you're concerned that mom may not have had capacity, or there might have been something untoward going on. So unfortunately, no contest clauses are not the complete answer, but they can help as a disincentive. If somebody just didn't like what you did and they filed a contest, then yes, it would be effective, and they would lose their inheritance. So that's the way to do it if you want.
Gotcha. Okay. One question that came in earlier: if an older person has a large IRA, what are some estate planning options they can use to avoid their heirs getting hit with high taxes?
So I saw that question, and I did touch on IRAs a little bit. Yeah. The fact with an IRA is that the whole purpose of the IRA is to allow you to save money and let it grow before you pay tax on it. And the trade-off you make with the government when you do that is that every dollar that comes out of that account will be taxed. So whether you take it out yourself and pay income tax on it, and it just becomes an after-tax account that you pass on, or if you die and you have an IRA and it passes on to your beneficiaries, whatever money comes out, there'll be an income tax for it, just like it was earned income. So if they're in a very low tax bracket, then there may be very little tax owed on it. But if they're in a higher tax bracket, it may be substantial. Something you should know about IRAs, a change to the law that just happened within the last about year and a half is it was called the Secure Act. And a lot of good things happened in the Secure Act, like not having to take required minimum distributions just quite as young as you used to. But one of the downsides is that your beneficiaries now have to take the money out of that account within 10 years. They can't stretch it over their entire life. So unless they're disabled or there's a few narrow exceptions, your beneficiaries have to take it out within 10 years. And so that can result in some heavy taxes. And the government's not exactly upset about that.
Right, I'll bet. Last question for now, unless any others come in. It seems that a financial power of attorney becomes ineffective at the time of death. If this is true, how can we access the assets of the deceased to pay for immediate funeral expenses?
That is a great question, a very practical question. So you're right. A financial power of attorney, like I mentioned, ceases to be effective on the death of the principal, because what you're really doing is acting on authority. And if the person no longer is alive to give you that authority, then the power of attorney can't work. So there's a couple of ways around this. One is that a lot of forward-thinking clients of mine will set up a small joint account, maybe $10,000, $20,000, with their intended fiduciary, so the executor, or if they have a trust with a trustee, so that they don't have to wait for death certificates. They don't have to wait for certain things to come in, and they can act on it right away. Another rather practical matter, if anybody has credit cards, you know this. If you have a credit card and you and you pay it every month, you have a grace period. So a lot of clients' children end up just putting those funeral costs on a credit card. And by the time the bill comes in and they're responsible for paying it, now they have access to the money. So it seems kind of simple, but that's another way of handling it that seems to work for people, and you don't end up having to pay interest necessarily.
Gotcha. Thank you. That's very helpful too. You're right. A very practical question. One last question. How do we deal with powers of attorney when dealing with the federal government? I hear that Social Security and the IRS, that they don't recognize powers of attorney, and a person with ALS cannot sign forms for themselves, but can make their own decisions.
That's a great question. Basically, every question's been great, but that's so on the nose for a lot of people. Yeah. So the Social Security Administration is the one that most people think of if they're veterans and they're getting veterans benefits. I didn't mention this. I'm a VA accredited attorney as well, so I help veterans with their benefits if they are entitled to them. And the VA has its own process as well. You're right. They don't accept the power of attorney. They very kindly tell you that, no, we have our own process for doing that. They don't even really accept conservatorship. So you can even go to the process of having a state court judge appoint you conservator, and they say, well, that's great, but we have our own process. The Social Security Administration process is called the Representative Payee Program. And it applies to people that have a disability or people that are in retirement, receiving retirement income and start to lose capacity. And what it is just a process of going to the agency and establishing who you are and giving them some evidence that you are the right person to be making decisions for them. A power of attorney can be some of that evidence, but it's not something where you can just slam the power of attorney down on their desk and say, it makes me the representative payee. They're not going to just go with that. So the answer is, going through their process, if you go to ssa.gov, Social Security Administration, there's a section right there on the website about the Representative Payee Program. It has certain requirements. You're accountable for every bit of money that comes in to that Social Security beneficiary, and you have to swear under oath every year as to what you did with it. So there's a process, but it's there to protect the people who are entitled to the money. And you just have to follow the bouncing ball, follow their process for getting recognized as the fiduciary. It does not necessarily require the signature of the disabled or retired beneficiary. I know some agencies, I think they're more state agencies like Medicaid, will sometimes say, well, to get appointed representative, you need the signature of the person that's signing. And sometimes I think the VA may have some forms that are like that as well. And my advice is simply do your best. If they want an X or a signature, then ask the person to do it. I can't say that they're going to necessarily understand, but if that's what they're requiring, then go through the requirements. But for the rep payee program is not like that. It's very well organized. You can imagine many people need representative payees. And so, I would hope that it'd be fairly straightforward. Was I answering the question? I want to make sure
Yeah, I think you did. And I'm so happy that you have your contact info up here too. For anyone who's participating tonight on the webinar, please do feel free to email or reach out to Christopher anytime via phone. Thank you so much for being here, Christopher. I think we have some other slides we're going to share. If you don't mind,
sure. Of course, I will unshare.
Popping that down, and then Jennifer will get the other slides up. And I think we are going to wrap up tonight. Thank you so much, Christopher, for being here. You answered some very important questions for several of our families tonight. Much appreciated. And thanks so much to all of you for participating on the call. We're really grateful to each of you for your time and commitment tonight, and really just for being a part of our community. We have some events coming up in the next couple of weeks. Just a couple quick reminders. Please do join us for the virtual Jim Tracy 5K this coming Sunday, April 25th, and the virtual SoCal Ride, Walk, Trail Run to Defeat ALS on May 15th. We also have the Eat to Defeat ALS on Saturday, May 22nd, and the next installment of our Ask Me series on Wednesday, May 26th. I think it's the next slide. That will focus on speech issues in ALS and devices that can help. In addition to the information provided today, the Golden West chapter offers free resources that you can find online at alsgiftplanning.org, including a free estate planning guide. As you know, philanthropy fuels absolutely everything we do, and some people choose to support the chapter's programs through an estate gift. If you wish to learn more about that, please reach out to Emily Stork, our Director of Development, and she'll be more than happy to speak with you. Also, please watch for the short survey on tonight's presentation that you'll receive via email in order to help us plan for future programs like this one. Thanks so much again, and we'll see you next time.